Mr. Caparella, you seem to be following me around the state. A couple of months ago, I was in Knoxville, and you went there, and now I'm here, and you're here. I may get out an order of protection or something.
Well, July 6th, I'll be in the middle section, and if you're there, I think you'd be entitled to seek one. Your
Oh, I
Honor.
hope I'm somewhere else.
I'm not real sure what that says about either one of y'all.
I agree. All right.
Good morning, Your Honor. I'm Donald Caparella, National Bar, representing Janet Graham in this case. I'd like to reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
Your Honor, this case raises the issue of spoliation of evidence. It's our position that it's an abuse of discretion to dismiss a plaintiff's case entirely for spoliation when the trial court never finds any specific prejudice from the spoliation of the evidence. The dismissal is the harshest penalty a trial court can award, and it's the obligation of the trial court to set forth in its order the specific prejudice to the defendant. Here's what the trial court said about the actual specific prejudice. This is page 850 of the technical records from her order. Thus, due to plaintiff's intentional deletion of text messages, defendant does not have access to what is possibly critical evidence to its defenses in this case. That's it. What is possibly critical evidence. There are lots of speculation about the deleted text messages that it could be prejudicial, but there is no specific finding of prejudice. So we submit, Your Honor, that this case is governed by specialty case from 2018, where the Court of Appeals reversed a default judgment that was granted. And of course, the default is the mirror image of a dismissal. In that case, the trial court made similar vague findings of prejudice in the order, and it's what's in the order that is the focus of this appeal. The trial court found that the discovery had huge gaps, excluded relevant documents, and was deficient. And the Court of Appeals said, and I quote, "When imposing the harshest of penalties, such as dismissal of the lawsuit, the trial court must endeavor to explain not only the violations, but also how those violations prejudiced or otherwise affected the complaining party so as to justify dismissal." The trial court never did this. It focused solely on the intent. Trial court here said that due to plaintiff's intentional deletion of messages, defendant does not have access to what is possibly critical evidence. So essentially, there's no way the defendant can defend themselves. Here, all the allegations in this complaint are about in-person discrimination. Things that happen in the real world, nothing to do with text messages, nothing to do with, documents and stuff like that. It's just witnesses seeing her and other women being severely discriminated against. Now, the trial court, because of all the false negatives that Mr. Ted Scott found, where he initially found thousands of emails and texts had been deleted, and then it got whittled down to the 199 that she allegedly deleted after her deposition. What's interesting about those 199 text messages is they were deleted after her deposition, but they are dated. Those text messages are dated in 2019, and she filed suit in 2018. So these are text messages that have nothing to do with the actual core of this case, which is the allegations of misconduct. And importantly, a great many of those text messages, the information was recovered either partially or completely. Of the 199 text messages.
Do we know who the text messages were sent to or who the parties were?
Yes, and the trial court focused on those 199 that are post-deposition. And this is a very important exhibit, and I brought it. It's in the record, Exhibit 1, and Mr. Scott put it together. Of the 199 text messages, 77 are texts from Miss Graham to Miss Graham. They're called self-texts. Another 118 of those are text messages in which some or all of the information has been recovered. You can see who it was sent to, or there's information about what was said. And again, these are text messages that are in 2019, a year after she filed suit in this case. And then that left four text messages, again from 2019, that according to Mr. Scott, you couldn't find anything about. So how can the trial court simply speculate that there's no way that the defendant in this case can defend themselves for in-person discrimination because of texts that were deleted years after this alleged discrimination came along? And the trial court in Technical Record 862 expressly said that there were a lot of recovered information about these 199 text messages. So it's a totality of the circumstances test from Tatum. The trial court focused exclusively on what she found was the intent. After the deposition, Ms. Graham supposedly deleted these text messages. But it's not the deletion of text messages that matters exclusively. It has to be relevant evidence. It has to severely prejudice the defendant, and it has to match the punishment. If these text messages were deleted, they can put evidence of that during cross-examination of her, and they can try to impeach her credibility with the jury. But to say she doesn't even get a chance to come before the court because she deleted, because 199 text messages were deleted after his deposition, when those text messages are a year after the suit was filed, goes too far and goes against the specialty case and several other cases. The cases that support the finding of absolute dismissal with prejudice in a spoliation case are cases where it's a piece of evidence that, for example, a tractor in a tractor-trailer wreck where the trailer supposedly messed up, but the defendant says, no, it was the tractor that messed up, and the tractor's destroyed. How can the defendant in that case, the court found, how can the defendant possibly dismiss that? I mean, how can the defendant possibly defend that kind of a case? It has to be something that goes to the core of it. And the core of this case is whether this discriminatory conduct over years took place. Now, no depositions of these witnesses who were on the other side of these text messages were taken. No depositions of the witnesses, well, they point out that some of these text messages were between Ms. Graham and some employees of UTROP, of the defendant. But those depositions weren't taken. There was never an attempt by the defendant to try and find the other side of this, nor was the plaintiff allowed to do that as well. Now, I have to point out something that's important, I think, for the record in this case.
Isn't there some proof in the record about the appellant reaching out to a former employee and discussing the activities of a specific doctor and, we're going to get him or something like that?
Yes, and that's from 2017,
Okay.
before the lawsuit was filed. Cara Fisk was her name, and Ms. Graham produced that text.
Okay.
And Cara Fisk was never interviewed by the defendant. As a matter of fact, the defendant testified that the whole text between her and Cara Fisk was immaterial. And the trial court, when it incorporated the transcript from the ruling to go with the order, incorporated that statement into its order. So effectively, the court has made a finding, or at least the defendant has admitted, that that entire exchange was immaterial. What defendant's argument is, because we know that text happened, and because we know there are some other texts that are missing, we'll never know what those texts say. And therefore, she may have done some other bad things in those other texts. So therefore, we can't defend ourselves because she may have said some other bad things. That is the kind of speculation that the case law makes very clear. You cannot dismiss an entire case unless you can make specific findings that the piece of evidence that's missing prevents the defendant from defending their case at all. They have no way to defend the case. This is all about impeaching Ms. Graham or challenging the in-person stuff. Essentially, Mr. Scott started out with thousands of texts that he said were deleted. Then he admitted his software program was wrong. And then everything got whittled down in a complex record to the 199 texts. And I would like permission to hand you this exhibit that just cuts right to these 199 texts. And you can see that, or you can at least acknowledge it. It's Exhibit 17 of Volume 17 of the it's Exhibit 1 to the transcripts in Volume 17, and it's a list of 199 texts, and then we have this also very important, there it is, this important email dated November 7th, 2019 from Mr. Scott, where he lays out, yes, it's the 199 that I found, and he points out that there was all this recovered information for 118. So how can the trial court simply speculate that the 2019 text messages, which is what the trial court focused on, so severely prejudice the defendant that they cannot defend themselves, period, when they can use the absence of these texts for impeachment, but they can't show the actual prejudice the way you can when you have a missing tractor trailer, a missing gun, missing range that, caught fire, so you can't do an arson investigation. Those are the cases that justify the most severe type of penalty in this case, which the trial court found. And all the cases look to the trial court's order. What's in the order? Please read the order and see if you can find any specific prejudice. Now, the trial court also made a finding that under not just spoliation, but under unclean hands, that this case must be dismissed. And the unclean hands was the court's finding that Ms. Graham was untruthful about deleting those post-deposition text messages. That's not the way unclean hand works. I couldn't find a single case where unclean hands was used instead of a spoliation analysis. Unclean hands is designed for cases that are filed in equity, in courts of equity, and this is an employment discrimination case seeking back pay, other statutory damages, and only one cause of action for specific performance. If the court found that she had unclean hands, which I submit she does not, it could have dismissed the specific performance and claim and tailored the remedy here. But also, unclean hands, the fraud in unclean hands that underlies it has to go to the core of the case. All the bad conduct by Ms. Graham that they're alleging relates to the discovery process and not to something that happened during the actual discriminatory conduct. And to suggest that unclean hands is another ground for dismissing this case is inappropriate. And as I pointed out in my brief, the trial court actually never made that finding, her ruling. It was simply added in the order that the trial court signed, and that's why we have a lakeside argument about the unclean hands issue. So we ask that this court reverse this case and reinstate Ms. Graham's bond, because if you reverse this case and give her a trial on the merits, then the bond for the award of attorney's fees should come back to her as well.
And let me ask you to clarify. You say 199 text messages were deleted.
The trial court found that, yes.
And you're saying that all of those were created and originally sent in 2019, which was after the complaint was
Right.
filed in 2018.
That's what this exhibit says in volume 17. If you look at all the dates, all the self-texts are in 2019, all the other texts are in 2019, yes. And the lawsuit was filed in February of 2018, yes.
All right, thank you, sir. We'll hear from you on rebuttal.
Thank you.
Good morning.
May it please the court, Jonathan Hancock of the Memphis Bar, and I'm here with my co-counsel today, Ms. Emma Redden. And with the court's permission, I'd like to share my time. Ms. Redden is the one who dealt more intimately with Mr. Scott's analysis and conclusions, so I'd like to pass to her.
How
for
much
that.
time would you like to share?
4 minutes.
4 minutes, all right. We'll assign 11 to you and 4 to her.
Thank you, Your Honor. I'm going to start out with a few corrections of the record because I think they're very important based on the court's questions. First of all, to your question, Judge Clement, no, all of the deleted text messages that could not be recovered, they were not all from 2019. And in fact, a lot of the deleted text messages had parts that we could recover. And the best example of that is one of the text messages deleted after Ms. Graham's deposition talks about the fact that she was terminated and offered, I believe, a severance package. Well, that happened after her deposition. And so we know that it wasn't all in 2019. But most importantly, excuse me if I can, I think there's a whole lot of the story
Well, if it happened after her deposition, then that happened after the suit was filed.
Absolutely. And in fact, the trial court focused Mr. Scott's analysis only on things that were deleted after the deposition. Not because that was the only part she planned to look at, but because she wanted to start with that test period. Because during Ms. Graham's deposition, I got into it with her about, did you preserve text messages? Because her production just stopped. Excuse me, Your Honor. And at the end of that deposition, we felt uncomfortable that we had gotten the whole story. And so we issued a third set of interrogatories and requests for production. And we asked Ms. Graham, have you deleted text messages? And in response to that interrogatory, she lied. She told us in her deposition that she hadn't deleted anything, that she knew about her preservation obligation and she'd preserved it all. Then we issue discovery, and under oath, she verifies a response where she says, I only deleted a limited quantity. That wasn't true. What we found when Mr. Scott, and how did she try to hide that is important too. We said, well, we don't think that makes sense. We'd like to inspect your devices and see how many text messages were deleted. If you're telling the truth, you'd agree to that, but she wouldn't. She didn't agree to it. And in her brief, counsel makes a big deal out about the fact that she did ultimately agree to it. She agreed to it after we had a full-blown hearing, and the court said, I'm inclined to grant this. Y'all go out in the hall and see if you can work it out. So it wasn't like she just voluntarily agreed. But there's a lot to this story that's missing, and it deals with why text messages are so important and why they're such a big piece of our defense. And it's because if you go back and look at what she did produce, Ms. Graham, in her brief, actually claims that the text message that she sent, the exchange with her and Kara Fisk, that's the one we're talking about, and she did produce that text. The exchange simply evidenced Ms. Graham and Ms. Fisk venting about having experienced terrible treatment at UTROP, which did not affect Mrs. Fisk's potential interviews with UTROP HR. That's not right. And the reason this is such a big deal and why we moved for unclean hands is the rest of the story. What she did after sending that to Ms. Fisk was she sent Nicole Washington an email. And Nicole Washington is with UTROP, the HR is done by Regional 1. UTROP is actually the physicians group that provides patient care services for Regional 1 there in Memphis. Regional 1's HR, they were doing an investigation into Ms. Graham's claims. And when they did, she talked to Kara Fisk. She sends this text. Then she emails Nicole Washington, and she says, and it's unbelievable, she says, excuse me, she says, a person you should really speak to in regards to the unprofessional behavior from Dr. Cooper is Kara Fisk. She left our group several months ago, and here's the big lie. I have not reached out to her. That email is what she sent to Nicole Washington after texting Kara Fisk. And what did she say to Kara Fisk? Oh, honey, you are going to help me do it too. I have him right where I want him. I have him scared and that pissed him off. But my plan was to make him, lose his shit, and he did. And then she continues and says, but seriously, they will most likely be calling you. You were on my list. She was manipulating the investigation. She was trying to change the outcome. That's why text messages mattered so much in this case. And that's why Judge Corbin Johnson was right when she said the plaintiff, after that deposition, deleted 199 text messages. And when she looked at the defendant's ability to defend their case, she realized these text messages are critical evidence. They're how we found some of the most important evidence in this whole case. They're the reason that she lost her job. That email to Nicole Washington is why Ms. Graham was fired. And so at the end of the day, we're not talking about an unimportant piece of evidence.
You're saying the email to Ms. Washington is why the plaintiff was fired?
Absolutely. She attempted to manipulate that investigation. When she confirmed that in her deposition, that was the reason she lost her job. And interestingly,
Let me ask you, how does that email, or frankly, any of the emails sent after 2018, affect your ability to defend against the claims made in the complaint in 2018? Because as I understand it, the complaint went to gender discrimination in connection with assignments and also retaliation because of some allegation she made against a physician. Mm-hmm. How do emails impact that?
it's really more text messages. And the reason
Or
it's...
text message?
That's it.
How does it impact?
The reason they do is what we learned from what she did produce, and then we learned again from Mr. Scott's forensic examination, was that text messages are how these folks were communicating. This is how she was talking to other co-employees about the treatment she alleges. In fact, in this case, this is how she was trying to fabricate a claim and talk other employees into supporting it so she could, quote, set the doctor up to lose his shit. So she was not only discussing with other employees all of these events that she now says were the underlying discriminatory events, she was manipulating that all in text
Well,
messages.
if she was talking to these other employees, why couldn't the defendant depose the other employees to find out what was said?
Well, one of the reasons is because we don't know who all she sent text to. Part of the problem with this 199 is we don't know who they went to. We just know they were there at one
Well,
point and
you've
now they're
got a pretty
deleted.
good idea who her social circle was.
Not necessarily. There was a large group of CRNAs.
Well, if you took a deposition of 2 or 3 of them, they would probably lead you to another 2 or 3 or 4 or 5. That's the way it usually works.
They would, but we would never know what we didn't know.
No, you never do. That's exactly right. And if that were the case in a lawsuit, then every case would be dismissed. So we never know what we don't know. But as Governor Wilder used to say about someone who wasn't as smart as he thought he was, he would say, he don't know, but that's one of my favorite sayings. But anyway, but there were other ways to find this out, which means there's other ways to defend the action.
But
And it would certainly go to the credibility of the plaintiff, but
it would.
dismissal.
It would, Your Honor, but it would also, that presumes that the only people who received these missing 199 text messages, not 2, the only people that received it were people we can figure out who they are. And maybe the other CRNAs were part of that group, but she was probably also texting other people. In fact, we know it from what we could recover. So the evidence shows that this plaintiff, and in fact, the expert made this finding, and it's uncontroverted. She used text messaging more than anybody he's ever seen. The evidence shows that she is a prolific texter, talking about the exact substance of the lawsuit and then deleting it. And so we are entitled to the presumption that those were relevant texts. And one of the reasons we're entitled to that presumption is because at least one of those texts that we could produce was talking about this exact case
Now,
with somebody
weren't
else.
some of the texts to herself?
Sure, they were. And what she was doing, I think she was taking pictures of things with genealogy and then sending them to herself so she could store them in a file. There were a lot of those. And to be honest,
Wasn't that the vast majority of the missing 199 texts?
we don't know. It was the vast majority of the ones we could recover. The 199, we don't know.
I thought Mr. Caparella said that over 100 were sent to herself.
And that's not inside the 199 that weren't recovered. That is in addition to those.
That doesn't include the 199.
That does not. That is in addition. And another factor we've got with all this, when you get into the culpability, which is one of the big factors under Tatum, another factor we've got is the reality is culpability after Rule 34A comes in. Culpability isn't the main factor, but it's a big one. And she lied about it twice under oath. Then she wouldn't let us get her devices till the court made her. That's culpable. That's showing of an intent. And it's also incredibly important when we think about what could the court have done with this? Could a remedial instruction really have done anything? Do you have to try a case if you know what the outcome would be? No reasonable juror in this case, given these emails we already had in text, and given the negative inference for 199 text messages, no reasonable juror could find in her favor. It couldn't happen. The court really only had one remedy left. And this case is, for what it's worth, exactly like, and the court was very guided by this, even though it came before Tatum. Dr. Alexander's case, it's very similar. And what Judge Corbin Johnson did very well was she said to the plaintiff, here's the bar you have to jump. First, you have to recover the evidence. If it's unrecoverable, then I'm going to have to come up with some sanction. And plaintiff never jumped that bar. That's exactly what Dr. Alexander's case was about. If the evidence isn't recoverable, then what sanction is the most appropriate? And here, because it wasn't recoverable, and we're talking about 199 text messages, the trial court was right. The only appropriate remedy here and the only appropriate sanction was dismissal.
Did the trial court consider other remedies?
Sure, we talked a lot about remedial instructions, and I made the same argument I just made. There is no remedial instruction here that will give us the benefit of this spoliation without making this such a one-sided case. There's no use in trying it. And at some point, judicial economy is an important consideration. And so is
I've
expense.
never seen that.
What's that?
I've never seen where the trial court has made some finding that there's no way that a jury could decide in a person's favor.
I don't want to overstate that. That was my argument. I'm not sure the court adopted it.
I don't believe I've ever heard a court say that.
Yeah,
All right.
that only came out of my mouth.
Thank you. We'll hear from your co-counsel now.
Thank you, Your Honors.
Good morning.
May it please the court. I do want to talk about some of the specifics with the analysis of Ted Scott, the digital forensic expert. I'm happy to answer any questions about that. There have been a lot of numbers thrown around about the number of deleted text messages and sort of how that got whittled down. So one of the biggest points that I would like to make is that Mr. Scott in his original analysis found that over 2,000 text messages were deleted. Over 1,500 of those were after Ms. Graham filed her complaint, and over 400 of those were after her deposition was taken.
But didn't the person who came up with 2,000 admit later on that that was an error?
He did not. No, he never backtracked on that number. What happened was, during the first hearing on our motion for sanctions, Ms. Graham's counsel had some questions about some of the entries in his report where it appeared that some text messages that showed up as deleted were in there twice, which is what we refer to as duplicates. And those text messages were marked as deleted, but also unread. And so there was a question about whether those were duplicated entries, and if so, whether we should count only one for those text messages. So there was absolutely, they represented a deletion, but the question was whether the number was accurate. That did not apply to all 2,000 text messages. So, I mean, at most, even if we deduped all of the 2,000 text messages, that still leaves 1,000 that were deleted. What Mr. Scott did was he uses a software program called Cellebrite, and he was trying to determine what accounted for those potentially duplicated entries in his report. He never got confirmation that those were actually duplicate entries. He never admitted that the 2,000 number was wrong, because the trial court judge instructed us to focus on the text messages that were deleted after Ms. Graham's deposition, so the 412, setting aside the remaining 1,600, because she wanted to focus on those because that went most to Ms. Graham's intent. So we focused on that group, and Mr. Scott looked at the number out of that 412 that had this duplication issue. He took those out, and that number was the 199 deleted text messages that he was certain that was the accurate number that was deleted. He set aside those other text messages because it was kind of irrelevant. The trial court judge said, as long as he can still testify in his expert opinion with certainty that a number of text messages were deleted after her deposition, that's enough evidence of spoliation. So we focused on the 199 at that point. But he never said that those remaining 200 roughly text messages were not in fact deleted, or that number was incorrect. We just set that issue aside for the time being and focused on the 199. Out of that amount, 118 text messages had some recoverable content, whether it was the sender or whether it was the actual body of the text message, leaving around 77 or more text messages for which we could not recover any content. Out of that number that we could not recover content, we could see that there were self-text messages that Ms. Graham sent herself. And almost all of those text messages had an image associated with it, but we have no idea what those images were. There's just no way to tell, because she had this theory that she could find images on her laptop and match those to the deleted text messages. And that's what she tried to do both in our second hearing on the motion for sanctions and in her motion to alter or amend, where she got Donna Eno involved. There's no reasonable certainty that the images that she found are actually those contained in the text messages. There's not a file name that she can trace. There's not an exact timestamp. And Mr. Scott looked at this for her. The trial court gave her an opportunity to try to match those images to her text messages, and that could never be said to be certain that those were the images in those text messages. She thought she was sending herself genealogy photos, but we have no idea. And so the point is that Mr. Scott never changed his mind about how many text messages were
All right,
deleted.
well,
We
let
just
me-
focused.
Let me ask you this, disregarding whether it was 199 or 2,000, upon what evidence in this record do we conclude that your client would be unable to defend itself?
Because we have evidence that some of the text messages that she was sending, that she produced, and then some of the text messages that she was sending that she deleted are relevant to this case. And most importantly, those ones that go to her manipulating the conduct of Dr. Cooper, who she alleges was harassing her, and then her manipulating the investigation that UTROP had into her claims and her
Well, if you know
complaint.
that, then you can put on that proof. You know-
Sure.
You know she's manipulating, then put the evidence on.
There were other allegations in her complaint, though, and so we're not sure if she was texting other individuals about those other allegations, whether the trial court wanted us
You wouldn't have
to-
known if she made a phone call to somebody else or if she had lunch with them and had conversation in the old-fashioned way, in
That's true.
person.
That's true.
It's-
And I think a part of it
She
had to
could have
do-
said a lot of things to a lot of people to manipulate or attempt to.
Sure.
But anyway, all right, thank you so much.
Thank
Okay.
you.
Mr. Caparella, you have 3 minutes.
After all this talk, we're down to, again, the 199 that were deleted, the trial court found were deleted after the deposition. And you heard opposing counsel say that 77 of them were self-text because there's a sender and a recipient that are the same person, Ms. Graham. And then you have 118 that Mr. Scott says, and again, I'd be happy to hand this to you if it'd help you get through this record, if you want it.
You don't have to, what's the exhibit number you mentioned?
Well, that's why I want to hand it to you, because it's a little obscure. It seems to be a free-floating thing. It's called Exhibit 1, and it's related on page 766.
But if
So
we look in the record to Exhibit 1, won't we find that?
I think you'll find it. I don't know what it physically looks like in your box, but on my disc, it's called Exhibit 1, and in our citation, we do TR 766, Exhibit 1.
And that's in your brief?
Yes, yes.
Okay,
And what it consists of is a spreadsheet of 199 texts, and you'll see the self-text. You'll see a great many of them. The 118 shows partial information, either recipient or sender. It also shows a lot of the content of them. So we're down to that 199. The trial court did not dismiss this. Actually, the trial court didn't say which texts were missing. There's no finding about what specific evidence she said was missing, and therefore, that's why there's no actual prejudice, because it doesn't show. So I think Your Honor's hit the nail on the head with, if you're claiming, if the reason why you must have these texts, and because you don't have them, you can't defend your case, is because my client supposedly manipulated these witnesses, and they mentioned Dr. Cooper, Cara Fiss, Nicole Washington, take their depositions, find out if they were manipulated, get their side of the texts, or find out if she had lunch. They have a way of defending themselves in this case. I strongly disagree with the idea that they're entitled to the presumption that because these texts are missing, that they would say good things for us. And therefore, the case must be dismissed completely. That might give them a lower sanction than an absolute dismissal, but that's not an appropriate presumption. I think it's hotly disputed in this case, and not an issue in the spoliation claim as to her being her being dismissed because of a text that she sent to Nicole Washington. That may be their position as to why she was dismissed, but that issue about why she was dismissed is not an issue for the spoliation issue before you.
Earlier, you mentioned, I think you did, that the defense has not taken the depositions of these other potential witnesses.
No.
Is that in the record?
Well, there are no, it's undisputed that no depositions have been taken in this case.
Oh.
I mean, no depositions other than Ms. Graham and Mr. Scott, who's the person. None of their employees have been deposed, no. And so the other side of these communications and what alleged I don't know how you manipulate yourself into being discriminated against. That's a rather interesting theory. But they have an opportunity by interviewing those witnesses in depositions to find out whether that's true or not. So we ask that you reverse this case and remand it for a trial on the merits and, if appropriate, consideration of whether there are any sanctions that are due, but also because they got an attorney's fee award of $100,000 and attorney's fees and costs, which we posted as a bond. If you reverse, we ask that you remand it to the trial court to return that bond to her and allow the case to proceed on the merits.
All right.
Thank you.
Thank you, and thank all three of you for your arguments, and unfortunately, you too have given us a lot to think about, so we'll take this under advisement.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Everybody have safe travels. All right, call the next case, please.